When it comes to picking an estate planning attorney, there's a few considerations that you need to think about. First is you need to do background research on your lawyer. You need to know what their background is and what their experience is. How long have they been practicing and what sort of qualifications make them suitable to be your advisor. There's a few things that make our firm a little bit different from the rest. First, I think, is our collective background. Both Adam and I worked in an environment where we were geared towards litigating cases. And what that means is we usually were the lawyers that were called when there was a problem. When people would fight about things, when people would sue each other, you need a litigation attorney. And so having had the background of being in the courtroom, arguing for our clients, arguing in front of juries, speaking with judges, we think we have a very good sense of the things that could go wrong. And so working backwards, we try to plan in such a way so that we can prevent those problems from happening in the first place. Second is we don't charge hourly fees to our estate planning clients. I used to work at a firm where every time the phone rang, every time I made a photocopy, every time I did anything related to a case, I was told to bill the client for that time. And what I found was that people stopped wanting to talk to their lawyers because they didn't want some big check to come out in the mail for a 20-minute conversation they had with their attorney. And with estate planning, I want to make sure that our clients have the luxury of calling us anytime they have questions. We just bought an asset, what do we do? We just had a new child, what do we do? They shouldn't have to worry that just because they're talking to me for 5 or 10 or 15 minutes, that somehow we're going to bill for that time. So we took hourly billing off the table. In fact, our clients get to pick their own plan. And so there's no surprise bills in the mail. There's no questions about what's something going to cost because they know ahead of time exactly what they're going to get. The third thing that makes us a little bit different from the rest is we actually have a team approach to estate planning, whereas some attorneys are either solo practitioners or you have one lawyer sort of doing all the work. We have different members in place that do different things. So for example, we have a drafting coordinator, an attorney who does nothing but draft our estate plans. And this attorney who drafts our estate plans makes sure that all the provisions in the estate plans are up to date, they're updated with the law, and that as the law changes, so do our estate plans. And that's very important to know as a consumer, because a lot of people who do estate plans are using estate plans that were built decades ago, and they're just changing names. And that's, again, a sign that you need to do more research when picking your estate planning attorney. So we also have a funding coordinator in place, and all this attorney does is make sure that assets are funded correctly into the trust. I think this is the number one mistake people make when it comes to their estate plans is they get the legal documents, they sign the legal documents, and they think they're done. But in reality, their estate has absolutely nothing owned in the name of the trust because none of their assets have been transferred to the trust. And I think a lot of attorneys aren't in the business of doing that. They have a volume-based practice where all they do is churn documents and get them signed. The most critical thing to do is to make sure that your assets are actually named correctly in your trust. And we have a full-time lawyer who's had 25 years of experience doing that. The last thing that I think makes us a little bit different from our competition is that we approach estate planning very differently from others. When we hand clients their documents, their estate planning documents, we always tell them that this should be the beginning of our relationship, not the end. And the reason for that is as people create estate plans, no matter what, things are going to change. Their family's going to change. Their assets are going to change. The law's going to change. And these are three things that are indisputable. So when we know that those things are going to change, we also know that the estate plan necessarily may have to either be changed, updated, edited, modified, or looked at. And no matter what any of those things end up being, we need to make sure that our clients are in a position where they know that they can reach out to us anytime they have questions down the line as those things change, without having to worry about a bill in the mail, without having to worry how that's going to affect their overall plan. So we try to do it from a lifetime aspect, counseling our clients from a lifetime relationship, because ultimately, as those things change, so will your desires and so will